Good evening, everybody. I have a great pleasure in introducing Mr. Yemi Akisani, or he is called as Edemi Akisani, who is from Nigeria. Born in 1954, he obtained his LLB honors in 1972 and was called into the Nigerian bar in 1977 as a solicitor and advocate of Supreme Court of Nigeria and was enrolled as a notary public in May 2014. After brief stint between 1979 and 1981 with firms of Udingineri and Adifulu and Sullivan and Cromwell in Lagos and New York, respectively, he joined the Office of General Counsel of Mobile Producing Nigeria Limited, MPNU, in November 1981 as counsel. He retired voluntarily early retirement from NPNU in March 2002 after 21 years plus of service as counsel, senior counsel, acting general counsel, and company secretary. Amy Akasani is a CEDR accredited mediator, that is Center for Effective Dispute Resolution UK, an associate of SCMA Standing Conference of Mediation Advocates UK and Nigeria, and an SCMA certified trainer in mediation advocacy. Apart from an active private mediation practice, he serves on the panel of neutral of several mediation institutes, including but not limited to Lagos, Multi-Door Courthouse, the Dispute Resolution Panel of Nigerian Electricity Regulatory Commission, and the Federal High Court of Abuja ADR Center. In collaboration with other practitioners in ADR and conflict management, he has established the Dispute Solution Hub. PDSH gives clients optimum access to best in mediation and conflict resolution and management service programs, advisory training and development, including workplace mediation, employee rights mediation, conflict coaching, host community relations and negotiation, and union negotiation. It also serves as a private center for the conduct of private mediation and non-adversarial dispute resolution process and meeting. Outside of mediation and law practice, Amy is an ordained pastor and a Bible teacher, a classic pianist, and a choir trainer director. His other loves including reading, philosophy, science fiction, and Christian apologetic. He is married with children and grandchildren. I welcome you, sir, for this program. We at the Tamil Nadu Mediation Association is very happy to invite you, sir. I now request you, sir, to address us.
Thank you very much, Sudha. I really appreciate. I always feel very flattered when I hear my introduction read, because it's like I say to myself, "Wow, is that me?" Well, thank you very much. I want to say thank you very much for inviting me. I look forward to doing this, and I'm hoping that this will be the beginning of a long and a continuing association with the Tamil Nadu Conciliation, Mediation and Conciliation Association. And I promise you that I will always be available to you at any notice to do anything you require me to do. I'm very passionate about mediation. I love mediation. I got interested in negotiations and mediations when, in the time of my working with Mobile Producing Nigeria, we had to deal always with problems with our host communities. Sometimes we had oil spills and we had people rioting against us. And because my company then was very litigation averse, and they believed that the philosophy of Mobile Producing Nigeria at that time was that you do not fight with your hosts. You must never engage them in fighting. So we were always required to go in there, talk to them, find out who you can speak to, get the youth leaders, get the community leaders, talk to the villagers, find out what they want, and let's discuss. And with a view to getting an answer. And that sort of, I think it laid a foundation in me, apart from other influences from my background, in always realizing that there is hardly any conflict that cannot be resolved if parties would diligently and patiently identify the relevant issues and factors and find a common ground where they can agree a way forward in their relationship without ending it and without becoming hostile. So that is the one thing that I've enjoyed. It has played out very well, and in the last 3 4 years, I've gradually wound down my active legal practice to the minimum. I do just mainly consulting and advisory work at the moment, and I concentrate 85% of my energies toward practicing and promoting mediation. It is, again, I say it is with great pleasure that I've accepted this invitation, and I'm willing to, I'm ready to discuss with you some of my thoughts on court and mediation, court and community mediations in Nigeria, especially in Lagos. So once again, thank you very much. Now, I don't know if you'd like me to go ahead, and I would do so.
Yes, the stage is all yours, sir.
All right. Now, I assume that there'll be questions at the end, so I'll try not to take too long, but I'll also try to ensure that I give you sufficient information. I have prepared, mainly to guide me and to ensure that I stay within time, a little word presentation that shows it's just a Word document which I've made for the purposes of this presentation, so that it can guide my thoughts and ensure that I don't go off tangent, which I tend to do when I'm not guided. And I'm sure that you'll be glad that I did not go off tangent. So, if I may, I would like to just share my screen so that you can go along with me as I talk about community and court mediation in Nigeria. As an introduction, I'd like to mention the fact that um, Nigeria is one of the countries in the world, and I suspect India, where the adversarial system of civil justice has dominated the judicial landscape, and it is practiced today as received from its colonial masters, Britain. Of course, in very many ways, it has added its own flavor to it, and we have departed. Britain has gone off, has developed a little further than we have. But based on that tradition, the traditional courthouses have been the places where people go to. And as you probably would know and understand, we have the high courts, we have the magistrates' courts, we have the customary courts, we have also the appellate courts, we have the Court of Appeal, you have the Federal High Court, we have, of course, the Apex Court, which is the Supreme Court of Nigeria, which is the highest court of the land. Now, all of these courts, traditionally and by the laws setting them up, offer to the public only a one door for resolving disputes, and that is the litigation process. You filed your case and you have to establish your case in the courts. You have to prove your case, and there are technical rules, there are rules of procedure that have been established. You have the law of evidence and the rules of evidence, and you present your evidence not based on what is the truth, but actually what are the facts that you can establish uh, in accordance with the technical rules applicable through the law of evidence. So that litigation process is there. Now, events and developments over time, and especially recently, have shown us that in Nigeria, generally, everybody, lawyers, non-lawyers, the leaders of the country, the politicians, the governors, the president, we all appear to at least have bought into one reality, which is that disputes are perennial, they disperse energy, they disperse time and finances. Now, when I talk of energy, time, and finances, believe me, I mean it. Because when you speak of a matter, I know, not hearsay, I have been involved in a case which we began in 1989. We started this matter, it was a family matter. We engaged other lawyers. I was not representing the family at that time. I was still working within the legal department called Office of General Counsel in Mobile Producing Nigeria Unlimited. But we had some issue over some family property in which somebody had illegally occupied family property and sold it. And we went to court to get redress. We were in court in 1989. The matter was eventually resolved in the law court at the first instance in 2008. That is almost 20 years later. And as soon as we resolved the matter and it was resolved in our favor, the other side went on appeal. And that went to the Court of Appeal and remained in the Court of Appeal until the Court of Appeal threw it out in our favor in 2014. And even then, this year, believe it or not, the parties have come out again and they've made an illegal claim to the property, and we are back in court trying to get a relief. Now, if I think of that from 1989 to the year 2019, that is 30 years. You can imagine the time, the energy, the finances that this has cost. So, and this is not an unusual, is not a unique case. Many cases are like that, and generally the government, the profession, the people are generally getting tired of this, and they realize that, look, listen, disputes will always be perennial. They disperse energy, time, and finances. There has to be a better way of dealing with this. And we're therefore realizing that it is becoming a cog in the wheel of progress, and that we need to find better ways of encouraging amity and amicable resolution of disputes, because this is the foundation for progress and development. And if this foundation is not there, it will continue to be a cog in the wheel of progress. Now, we realize that while conflicts cannot completely be eliminated in human relations, at least we now realize, and I think we all buy into the idea, that it is desirable not to allow conflicts to escalate, but to resolve them in an amicable manner. And in that direction, um, court mediation was instituted. And one of the first places where we began to practice court mediation in Nigeria is through what is called the Lagos Multi-Door Courthouse, which was established in June 2002. The name multi-door, which actually was coined by some Harvard professor much earlier than this, um, is derived from the multi-door courthouse concept, which envisions that there should be more than one way to resolve a dispute. So it envisions one courthouse, but with multiple dispute resolution doors and programs. That multi-door courthouse concept arose out of the realization that litigation is not the best choice, is hardly ever the best choice for resolving many, if not a majority, of disputes. Now, in the multi-door court system, which has been instituted in the Lagos multi-door courthouse, and you may recall when my introduction was being made that I'm actually on the panel of neutrals of the Lagos multi-door courthouse, LMDC. Um, what happens there is that when cases are filed in court, while cases are filed in court now because of the multi-door system, there are 3 or 4 things that happen preliminarily. There is a screening that is done by the court, the court managers who are given to them by the Lagos multi-door courthouse on what the court refers to as its ADR track. What happens that they are screened. They are screened and they have been trained to see whether there are elements within this case that makes it eligible for certain other doors for resolution. So when they do that screening, they sometimes also would accompany it with what is called a pre-trial conference or a case management conference where they would discuss the matter, the issues involved, and determine the appropriate door or what might be a preferable or a good door for resolution. And in this process, parties are offered a range of alternatives, such as mediation, arbitration, case evaluation, med-ab, that is a combination of mediation and arbitration. Sometimes, not very often, they also offer what is called a private judging and mini trials. And the case evaluation is what we call an early neutral evaluation, where parties are allowed the benefits of usually retired judges who are able to look at the matter and can let parties realize, look, based on this is likely to be the outcome of this. Why waste your time? Why don't you just resolve it this way right now? The cases are screened and evaluated, like I said, to determine which dispute resolution process is the most appropriate. And the cases are referred through the appropriate door for resolution. Now, the goals of a multi-door approach are to provide citizens with easy access to justice, to reduce delay, and to provide links to related services, making more options available through which the disputes can be resolved. And that is one thing that the Lagos multi-door courthouse has done very effectively, like I mentioned earlier. Now, Lagos State has been the first in 2002, but since then, many other states have set up similar processes. I know of Lagos State, Oyo State, Ogun State, Delta State, Edo State, Enugu State. Out of Nigeria's 39 states, there must be at least about 23 or more who have adopted the multi-court approach. May I please just be excused?
What happened?
Please pardon me. Now, Lagos and other states, as I mentioned, are made similar courts, and under this process, they've actually gone ahead and made laws under their respective court procedures, which require pre-action protocols incorporating mediation. Now, let me explain how this works. Ideally, I must confess to you that many lawyers and even parties are not being compliant. But typically or ideally, what should happen is that if I have a matter against some other party, the proper thing I'm supposed to do is to write a letter to the other party and to state as clearly and as succinctly as possible what are my grounds for my dispute and for the case that I have against that other party. Okay, now, and I should also, under the same letter, invite them to mediate the issue. Now, if the parties agree, we will then set up a mediation process, either privately between us or through the auspices of the Lagos Multi-Door Courthouse. Now, a mediation may end up either in settlement or non-settlement. If parties settle, then they will just simply file their settlement agreement in the Lagos Multi-Door Courthouse, and it will be entered as the judgment of the Lagos High Court with respect to that matter. And usually, settlement actions are not subject to appeal. However, if parties are not able to settle, they should also record that, and wherever necessary, with the help of the mediator, they should be able to state forth the reasons why they were unable to settle. Now, since they were not able to settle, they will be able to go ahead and file their matter in court. Now, the rules of court require them that at the time they're filing what we know in law as their pleadings, that's their statement of claim, they're required to file along with the statement of claim, along with their pleadings, something that is referred to as the pre-action protocol bundle. That pre-action protocol bundle is the bundle of documents and narrations that set forth very clearly those actions that they have taken to try to resolve the matter before filing the real case in court. Now, where a party refused to submit to mediation, to absolutely, the court will take judicial notice of that. We don't have any strong precedents yet to know what the courts will do or have done, where this has been. I regret to advise that many legal practitioners themselves are not being cooperative. They either very passively or carelessly follow this pre-action protocol, which is a shame, because if they did follow it sincerely, it would help the resolution of disputes within the state. Now, the Federal High Court and the National Industrial Court also have ADR tracks that require parties to consider mediation or other ADR before full-fledged litigation. And all of these courts, like the Federal High Court, has an international ADR center, in which the Federal High Court itself has the power to direct parties to that international ADR center. The parties may also ask to be allowed to go to the ADR center. And in all of these cases, wherever they settle, their settlement is entered as a settlement of the court. The National Industrial Court also has this track. It is particularly impressive in the case of the National Industrial Court because the National Industrial Court is one of the few courts of first instance that you are not allowed to appeal from its decision except in the strictest of circumstances. So, as much as possible, the court gives opportunity to parties to resolve their matters outside the strict legal process so that they can address matters that may not be suitable for the technicality of the law, but which will be suitable to the principles of mediation and conciliation. And this they do before they go to full-fledged litigation. Now, I'm pleased to mention to you that the Court of Appeal actually now even has a mediation practice as well. Now, with the mediation practice and the Court of Appeal, it means that even after parties have spent time in the Court of First Instance and have now come to the Court of Appeal, the Court of Appeal still gives them an opportunity to look at their matter to see whether they can resolve the issue by mediation. And I'm pleased to mention, although I have to confess that personally I've not been able yet to study in detail and properly what this process is. It's a new one, that even at the Supreme Court of Nigeria, the apex court, there is provision for resolution by means of mediation rather than having a pronouncement of the Supreme Court of Nigeria. Now, one of the exceptions to this, I believe, would be in a situation where a case requires a pronouncement on a state of the law or an interpretation of the law. I don't quite understand yet how this works. I'm studying it, and I'm hoping that maybe at some time in the future we'll have a chance to discuss this either together like this at your organization or on the auspices of my dispute solutions of TDSH at any of our round tables. But I'm pleased to say that mediation is alive and well in Nigeria, and parties are embracing it, even though, as I was saying at the introduction, when I was talking of mediation, some of what mediation really is not being really complied with. People tend to look at mediation as just an opportunity to compromise or to just simply settle a quarrel or etc., etc. And I believe it goes more than that. And because of this, it is taken away from mediation some of what I believe its proper benefits should be. But at least for starters, I must say that the court system in Nigeria has embraced mediation, and the way it happens is it is given the same importance as the regular cases. So to summarize it, in all of these places, even if you have a case, you can always file directly to mediate preliminarily, or the courts have the power to direct you to mediation. One of the things that people ask is, suppose a party refuses to cooperate and is just absolutely recalcitrant. Now, in the provisions of at least the Lagos state, which is the jurisdiction in which I practice, in the provisions of the procedures of the Lagos state, there is provision for recalcitrance. Now, under the provisions for recalcitrance, if a party has been directed to mediation by the court and the party just simply refuses to cooperate and is recalcitrant, the law actually provides that if the party is a plaintiff, that the case will be struck out. That is, you have filed your matter before the court, and it has gone through screening and it has been placed on the ADR track, and the court has directed you to go to mediation, and you outright refuse to cooperate, then you may come under the definitions and provisions for being recalcitrant. Now, if you are a plaintiff in such a matter, your case would be struck out. And if you are a defendant in such a matter, then default judgment would be entered against you. Again, there have been no tested cases yet. And one of the cases that I've been particularly interested in, but there is no decided case that I know of, is where a party has been recalcitrant and being a defendant, the default judgment has been entered by default against him or her, or it, as the case may be. Can they appeal against that judgment? What will be the grounds of appeal against that judgment? We don't know yet. There are no decided cases yet to guide us with this. But generally, we know also that even if the courts do not take that drastic action, we know that the courts would usually be inclined to award very high costs against recalcitrant parties. Now, the same thing applies in the Court of Appeal and recently the Supreme Court of Nigeria, the Apex Court of Nigeria. Now, one little known thing about mediation and even ADR, which I think lawyers especially are very conveniently ignored, is that the rules of professional conduct for legal practitioners made under the auspices of the Nigerian Bar Association also make it mandatory for a lawyer to inform his client of the option of ADR mechanisms before resorting to or continuing litigation on behalf of his client. I suspect that many lawyers don't do this. In fact, by the same rules, lawyers are actually barred from fomenting strife or instigating litigation. And I know that if I say this, many persons will wonder: is that true? Is that possible? Yes, it is so. Um, Now, except in the case of close relations or of trust, a lawyer should not, unless he's actually consulted for that purpose, should not give advice or encourage the bringing of a lawsuit. In other words, there's already something inherent even in the rules of practice that should encourage lawyers, even lawyers themselves, to support mediation and other non-adversarial forms of resolution. But of course, this has been observed more in the breach than otherwise. Now, so that is a brief summary, and I'll welcome questions later, which might enable me to discuss to explain away some other details. Now, although when I was invited by Kavita to take this discussion, we mentioned only court and community. But I thought to myself that it might be useful to look at what I would call those mediation opportunities. I'll call them midway. They're neither directly in the court, and neither are they fully in the community in that sense, apart from the citizens mediation centers. So that there are other institutions in the community that practice ADR, like the multi-door courthouses, and apart from them, and these include like the Lagos Citizens Mediation Centers. Now they operate in collaboration with the Ministry of Justice, Lagos State, and they primarily operate the process of dispute resolution by mediation. They primarily operate the process of dispute resolution, which we call mediation. They handle various disputes relating inter alia to landlord and tenant, employer and employee, family, debt recovery. They are almost like a small claims court, except that where the small claims court still employs an adversarial approach to resolution, the citizens mediation centers actually practice and offer mediation. Now, when you resolve your matter at the citizens mediation center, you would close by entering a memorandum of understanding, and this memorandum of understanding will be registered at the Lagos Multi-Door Courthouse, that's the LMDC, for the enforcement as a judgment through the machinery of the Lagos High Court. Now, there are other non-governmental institutions which exist that offer mediation that allows their members to resolve their conflicts. The various chambers of commerce provide this. And I've said to some of the persons who work with me that for those who want to pursue a private practice in mediation, these are areas that exist as opportunities for us because various chambers of commerce, various industry groups, such as estate surveyors, bankers, insurance companies, HMOs, health management organizations, and other private enterprises, they have within them institutions that provide for their members, that provide an avenue for their members to resolve their conflicts through mediation. And there are persons who are appointed as mediators in those places. Now, Nigerian laws also provide for the application of mediation, arbitration, and other alternative dispute resolution in various institutions. Now, I can't list all of them, but they include, for example, the Dispute Resolution Panel of the Nigerian Electricity Regulatory Commission. I'm a member of that dispute resolution panel, and is essentially provided for the electricity market operators to resolve their disputes before the dispute resolution panel of the Nigerian Electricity Regulatory Commission without having to go to the regular law courts, not even to Lagos Multi-Door Courthouse. But the dispute resolution panel itself has power to resolve their dispute in a binding manner. The Directorate of Petroleum Regulation, DPR, also has recently established and opened an international ADR center for the resolution of disputes between operators and members of the oil and gas sector. There's similar machinery that exists within the Nigerian Communication Commission, within the Consumer Protection Council, the Nigerian Investment Promotion Commission, and under the relevant provisions of the respective laws establishing the National Boundary Commission, the Nigerian Copyrights Commission. I've had the opportunity of approaching and using that to resolve a dispute between some musicians and other art persons and the Musical Society of Nigeria, of which I am a trustee and the honorary secretary. The Advisory Council on Religious Affairs also provides for that. And I'm sure if you read the news, you know we've had several ongoing problems between Christians and Muslims and other religions and so on and so forth. These have been very helpful. And also the National Office for Technology Acquisition and Promotion, just to name a few. Okay, so that in a way deals with all the what I'd call the court-like methods of resolution, which have been done. That's why I said court and also midway. But then you also asked me, do we have community or what I'd like to call the traditional methods of dispute resolution? Yes. In fact, there's a certain school of thought that actually says ADR for us really means African dispute resolution. Now, traditional African societies have settled disputes and differences through conciliation and other non-adversarial dispute resolution methods. Now, I said it is doubtful if authentic mediation was practiced, though. And I say this because, in my opinion, and I may be wrong, but I feel that what happens in those traditional African methods is that the person or persons or the body or council of persons who decide who sit over it, they give them a decision. Um, the objective is similar to mediation, which is to reconcile the parties in a manner that engenders good and friend relationship, that promotes and protects the integrity of the community and the society after the settlement of the dispute, and provides for compromise and reparation for the wrong committed. But as I was saying at the beginning, if you might recall, uh, the one major difference why I hesitate and I'm reluctant to call them mediation is that the Council of Elders, the king, we call them Oba or Obi, depending on where, or Emir, depending on which part of Nigeria you come from, and the chiefs, or as well as community council of elders or a family council of family elders, they are the ones that take the decision. They exercise a lot of compromise, mind you. There's a lot of compromise, there's a lot of resolution, there's a lot of conciliation, there's a lot of emphasis on promoting the relationships of the parties as well as preserving the fabric of the society. Uh, but my concern is that those forums don't leave the resolution to the parties. They actually listen to both sides and recommend to them a resolution, which is slightly short of mediation. And I think that it's closer to conciliation than anything else. But nonetheless, it works quite effectively. And it happens, like I said, in the palaces of the obas, of the kings, as well as in community and family eldership councils. It also includes the marketplaces, especially among the market women. In most markets in Lagos, there is usually a chief market woman. She's called the Iyaloja. Iya in the Yoruba language, which is predominantly spoken in Lagos. Iya means mother. Oja is market. So, or marketplace. So Iyaloja means the mother in the marketplace. Every major market has an Iyaloja. And when the market women have conflicts and dispute among themselves, the primary port of call is what I would refer to as the court of the Iyaloja. And that place, they tell their stories, they tell their tales, and a resolution is reached. But again, like I said, in those places, the rules, the processes, the procedures are set by custom and tradition, nothing written as such. But again, as I said, most times the whoever presides over or whoever preside over make a decision, recommend a resolution. Now, parties usually go there knowing that they will comply. So in a way, it is sort of mediation, but in which they have abdicated their right of resolution to that central persons. There are other traders' unions and organizations. There is a famous market in Nigeria. It's an electronics market. You will never find any of those traders in any court of law. You would hardly find them suing one another because they will find themselves ostracized. They'll find themselves excluded. They would be like the English expression says, they'll be sent to Coventry. They'll it's just not done. So those things are settled among themselves. Now, in some states, Lagos State again being primary, you also have offices of what is called the public defender and other such ombudsman institutions, which again also provide opportunity for warring or conflicting parties to resolve their conflicts. And all of these things are there side by side the with the court mediation processes. And when you look at this, you'll now understand why ADR has been considered by some scholars and experts really in our part of the world as really an acronym for African dispute resolution, because the adversarial process has never been exclusive. The line of litigation has never been the exclusive line of resolving. These um, community forums have also been established either by law, such as the public defender, or by tradition, such as the traditional rulers or the marketplace leaders, for the resolution of their dispute resolution. So that, in a nutshell, is a summary of court and community mediation within Nigeria. And I'll be open to to share comments and to um, answer your questions as the case may be. Thank you very much.
Thank you, mediation. You said that if a person, the plaintiff, does not go to mediation, then the suit may be struck off, or if the defendant doesn't do, the suit may be ordered against him. But does that interfere in the voluntariness of mediation? See, basically, we are talking about mediation being voluntary process. Would it mean that there is a compulsory reference to mediation?
Yes, that that is difficult to deal with. But I'll tell you this, that people have asked me many times, is mediation voluntary? I'll say mediation is voluntary to the extent that parties have agreed to mediation or have agreed to any laws that compel them to mediation. You see, if I do not, if I'm under any law, I have a choice. I can be law compliant, or I can refuse. I can refuse to comply with the law and be ready as the case may be, if necessary, for me to face the consequences of not complying. So, in a way, I agree with you. It may appear to take away the voluntariness. But one of the things that I've shared with people is that if you and I enter into an agreement and we both, without anybody forcing us, we both say, Sudha, you and I, if anything happens between us, we will settle it by mediation and by no other method. If now something happens between us and either you or I go to court, I have the right to go to court to say, no, we agreed, we both signed it, and the court will be compelled to send us to mediation. In that respect, I don't think it makes mediation less voluntary. It just means that even though mediation is voluntary, it is still subject to appropriate law. And what the rules of recalcitrance says in the Lagos State High Court Civil Procedure Rules is that when you have filed your matter before the court has the right to ask you to go to mediation. If you refuse to cooperate with the process, you become recalcitrant, and therefore, just like a party can be sanctioned for contempt of court, A person can be, if you don't file your pleadings of defense in good time, your case maybe judgment may be filed against you. The same thing happens with recalcitrants. If you don't cooperate, then that is against you. I don't think it takes away the voluntariness of mediation in the full sense of the word. But yes, I can understand the consideration that yes, isn't this making it less voluntary? Yes and no. I hope my answer is clear.
No, but I wish this was a law in India, because we find lot of reluctance as far as mediation is concerned, or it is used as a dilatory tactics, in most cases. So I wish that the law in Nigeria applies even to us. I think Kavita will also agree with it. So that is there.
Yes,
Any
it's true. Yes, it's true. The thing is that, um, mind you, it's not as if, for example, there's several stages. If you go to court and the court directs you to mediation, if you don't want to be seen as recalcitrant, most lawyers have learned that an easier way to do it is just simply go through the process and just refuse to settle, in which case you have to be sent back to court. But if you just go out of your way and you deliberately frustrate the process. I've often said to legal practitioners when they've sat before me, I've said to them, listen, you have filed your matter in a court of law. The judge has directed you to mediation. If you do not wish to proceed with mediation, the proper thing for you to do is to file a motion before the same judge and tell him you do not wish to go to mediation. Then you can argue your case that mediation is voluntary. I have a right to not submit to it, and the judge will be bound by it. But if you don't follow that process and you just want to be lawless, I think what the rules are trying to prevent is a lawlessness, a right to just simply disregard, and that's why it uses the expression recalcitrant. You're just being recalcitrant, and that is not proper. I think the law has the right to sanction that without necessarily being in breach of the voluntariness of mediation.
Initially, sir, you explain about the court system, like customary courts, federal courts, and Supreme Court or Apex Court of Nigeria. What is that customary courts, sir? Does they only with regard to the customary in the sense, is that any traditional way of conducting court system, or it's a mediation system?
Now, the customary courts are not a mediation system. They are
Okay.
actually an adversarial system. However,
Okay.
customary courts
Courts.
they deal with matters of customary law. For example, if
Okay.
in Nigeria, just to give one example, in
Yeah.
Nigeria, it is possible for a man and a woman to be married either under the statute, where there's a marriage law which they can be married under, or they may not be married under the statute. They may simply be married through a traditional marriage system. And we have a traditional marriage system. And the family law that establishes what we call statutory marriage did not cancel the traditional marriage. And traditional marriage is respected, whether with regards to matters of succession and other rights and incidences. For example, if you're married under traditional law, you can practice polygamy in Nigeria. Now, if you have a problem with that and you want to sue your husband or your wife, whatever it is, or you have issues of succession, the proper place to file your matter is in the customary courts, which,
Courts.
which
Okay.
are able to determine by customary law what the rights and interests of the parties are. But those customary courts also have a right, they can ask parties to go and sit down together and go and sort it out. And so they also encourage and promote mediation. But the mediation at customary law level has not been as formalized as under the
Okay.
regular courts. Because anyway, that settlement, out of court consensual settlement, is inherent in the customs of the people, in the traditions of the people.
Okay, thank you, thank you. I just wanted to know, very eager to know about that customer. Was same way. Thank you. And I just want to clarify one more. This you were talking about more on this Legos code system, in Legos code referrals. So Legos codes initially they refer all the matters to the community mediation, or community mediation as such is the Legos codes.
Lagos Multi-Door Courthouse,
It's
the Lagos Multi-Door Courthouse is a part of the Lagos court system. So
okay.
when a matter is filed in the Lagos High Court,
Okay.
it goes through three stages. There's what is called the a screening process, where trained case managers working in conjunction with and with the registrars look at a matter and say, well, I think this might be suitable for resolution by arbitration or mediation or med-arb or so on and so forth. Then they also have what we call a pre-conference, a pre-trial conference process, where the lawyers on both sides come and sit down with the registrar and the court managers, and they determine that yes, this can be done at at by mediation. So if that is decided, it is then put into what is called the ADR track. That process, that under that process, they send them to mediation or any other ADR process as deemed appropriate. That's the way the Lagos Multi-Door Courthouse works. And it is called the Lagos Multi-Door Courthouse because on that ADR track, it may be determined that it will go to mediation or to arbitration or to med-arb or early neutral evaluation or private judicial settlement, etc., etc., or whatever they think will help the justice of the matter as quickly as possible in the best interest of the parties and to save time, money, and other troubles.
There was this thing that you'd mentioned that in case the matter is not settled, then the parties have to write why it was not settled. So wouldn't it take away the confidentiality, and wouldn't it make the process of mediation more cumbersome, because the parties would be scared to come out with the actual facts, because in case it is not settled, they have to write why it was not settled? Would that not be an impediment in the process? Because here in India, we do not write any reasons. There is one single line which is written by the mediator: matter is not fit for settlement at this stage. It's non-settled. We never give the reasons why.
I hear you, and I suspect that that might also be part of the reasons why people are resisting it. But usually that reason is supposed to be confidential itself, and it's really not supposed to be a commentary so much on the facts or the parties or whatever it is, but really just like a mediator's own observation as to why the matter was not settled. But what you're saying is is um is very right. And I've often considered myself that that might be some of the reason why parties do not want to go to mediation before. But the truth, however, whether we like it or not, is that until that law is changed, what is in the law now is that if I have a matter with you, my first step is to write to you, tell you what my issues are, and invite you to settle it. Now, if we decide, if you decide, no, I'm not interested, you can write back to say, well, I'm not interested in settling. And all that I need to do is to ensure that when I'm filing my case in court, I include my my letter to you stating my claim, my letter to you inviting you to settlement, and your letter to me declining that settlement. That's all I need to do. The only thing that may happen is that sometimes if you do enter a settlement process and you do not settle, then you may have to, it will be useful to put in your letter when you're filing your matter in court, to justify this, to say why why it was not settled. Usually, it would be the mediator, if you have been through mediation, who would indicate the reason why, in the mediator's opinion, why the matter was not settled. And I don't think, quite frankly, it takes away from the confidentiality of the matter. But I think it stands there to encourage parties not just to be arbitrary in their decision, not just to say, well, I refuse to settle. So going back to the issue of voluntariness, what I'm finding is that, quite frankly, mediation is not absolutely voluntary. I believe that it is largely voluntary, but there are certain circumstances, though rare, where that voluntariness may be qualified or limited, or maybe even taken away totally. And it will be presumed that it's because parties themselves have submitted to that voluntariness being limited, qualified, or put aside.
If I may add, like here in India, mediation is absolutely voluntary. There are no compulsions on the parties, Mr. Akisanya. And also, I feel that if at all we start writing as mediators, the reasoning behind non-settlement, and the judges will also have this bias towards the parties. Maybe one of the party has certain reservations about settling the matter. And if as a mediator, sometimes we do see when parties are not settling, we do realize that which party is actually the problem maker and the troublemaker in between the two. But still we cannot show or write or say put up a point, even if we feel that we can impress upon the parties that why don't you settle this matter like this. We are not supposed to suggest to the parties. They have to voluntarily come to that settlement. Otherwise it takes away the crux, the very foundation of the mediation. The mediation is built on the pillars of voluntariness, confidentiality. So I personally am a little not happy with the process going on in Nigeria if it comes to it, because this is against, like, world over. There is a pattern which is followed. Yes, in arbitration, yes, the arbitrator has the power. But as a mediator, we are facilitators. In India, we have facilitative, not evaluative mediation. We are following the process of facilitative mediation. So probably that is why it is very flexible, but our rates of success are high. If there is a general above 50% success rate in mediation, I feel we as a teething nation in the field of mediation have really reached far. So that is my take, and thank you so much. And no offense meant, but I just feel mediation is something which is totally voluntary, and confidentiality would be taken away if the mediator would inform the court that this is the reason, because we always know the reason why mediation has failed.
Okay, must say first of all that what you have said is absolutely reasonable, it's logical, in fact, it is correct. Let me say this categorically, that even in Nigeria, we believe that mediation should be absolutely voluntary. I want to tell you that that is
Thank
correct.
you.
Okay, that's
Okay.
number one. Number two, um, I agree with you that if a mediator states the reason why parties have not settled, it might prejudice the parties in a court of law. But really, the reason that the mediator gives for why they're not settling is not an evaluation of whether, oh, this party is wrong and they just don't want to admit that they're wrong. No, that is not that kind of reason. There are
Uh-huh.
ways and this is why mediator training is very important. That's why I
Mhm.
believe in the professionalization of the practice of mediation. These are the fine nuances of mediation that need to be taught. Let me give you two examples that might interest you. Example number one: in a court of law, the rules of evidence make certain evidences inadmissible. Sometimes an evidence has been brought before the court, and the other party by one side, and the other party argues against it and say, well, my lord, that evidence is inadmissible. Now, although it has been admissible, the court will be asked to disregard it. So the court is able to take a decision disregarding evidence that it has seen and heard. And the judge is trained to make a decision totally disregarding that evidence. It is my submission that judges must learn and be trained to disregard things that are not in the interest of the parties, just like they disregard um, inadmissible evidence, even though it has been presented before them. The second example, excuse me, has to do with uh, when parties have had an agreement. I don't know what the law is in India, but especially in arbitration, if you have a contract, if you have a contract in which you have agreed that if there is a dispute, parties will resolve it exclusively by arbitration. If one of those parties goes to court, the other party is allowed by law to bring an action stopping the case and to ask the court to order them to arbitration. It is my submission that even though the law does not exist like that, if parties have agreed, they have voluntarily agreed that they will submit to mediation, and one other party against that agreement goes to court, the court should have the right and the power to say, no, you voluntarily agreed to go to mediation, therefore go back to mediation. You should be able to do that. And I believe that does not take away the voluntariness of mediation, because from the beginning, the parties themselves agreed to mediate. I think the voluntariness of mediation has to do with the fact that I cannot compel you to mediation. For example, if I file a case against you in court, you have 30 days in which to file your defense. If you don't file your defense within 30 days, a default judgment can be entered against you. Now, you don't have that kind of thing in mediation. So, to that extent, mediation is voluntary. But if you have voluntarily agreed to mediate, I believe a court of law should be able to enforce your agreement to mediate without necessarily taking away from the voluntariness of mediation.
Thank you very much, ma'am, Sudarshana ma'am. On behalf of Tamil Nadu Mediation and Conciliation Center, we all thank you, sir, so much for your insightful presentation, sharing your experience. Moreover, we all felt very happy that you are a piano, not only advocate, mediator, all other field, you are expert and you're so experienced in your field. And thank you so much. You shared your precious hours with us and enlighten us. And I thank all the